Good morning, everyone. Thank you for joining us for this Lunch and Learn for Nevada judges, tribal and rural perspectives on protection orders. By way of introduction, my name is Sarah Herr, and I am the Deputy Director of the National Center on Protection Orders and Full Faith and Credit, NCPFFC for short, a center from BWJP. For those that are not familiar, NCPFFC is a training and technical assistance provider funded by OVW to provide TTA on all issues related to protection orders from issuance, service, and enforcement. We are very excited to have this partnership with NCJFCJ and our faculty today, because at BWJP, we have received a lot of TA requests when it comes to protection orders that involve tribal communities. So we know that this discussion will be very helpful for many. So if you have any questions throughout the webinar, please feel free to submit them over in the chat, like Anna said. Stephanie and I will try to highlight them at the end for our faculty to answer at the end of the presentation. So without further ado, I'll hand it over to my colleague, Stephanie Bowman from NCJFCJ.
Thank you, Sarah. Hi, my name is Stephanie Bowman. I'm a senior program attorney with the National Council of Juvenile and Family Court Judges based in Reno, Nevada. We are a judicial membership organization that provides training and support to judges and courts throughout the country on matters related to juvenile justice, child welfare, domestic violence, and domestic relations. We are also an Office on Violence Against Women training and technical assistance provider, including through our Civil Protection Order Guide project, which is the program at the NCJFCJ bringing this webinar to you today in conjunction with BWJP. And we focus in the Protection Order Guide project, we focus on stakeholder collaboration and emerging issues related to the issuance, service, and enforcement of civil protection orders. As I mentioned, we are funded by the Office on Violence Against Women as well as BWJP. So we want to make sure that we share the disclaimer that the opinions, findings, conclusions, and recommendations expressed today are those of the authors and do not necessarily reflect those of the Department of Justice Office on Violence Against Women. Also, for today's webinar, we have secured approval for 1 credit hour of continuing legal education in Nevada. If you are seeking Nevada CLE or CJE credit, we will submit your attendance records to the Nevada CLE board. Please also send me an email at Stephanie or at sbowman@ncjfcj.org, which I'll put in the chat in just a moment. And I will make sure to provide you with a certificate of attendance that also includes the program approval number for your reporting records. And so with all of that, I want to hand it off to our wonderful faculty today for our webinar so that they can introduce themselves.
Thank you, Stephanie. Well, hello, everybody, and welcome. We're glad you're joining us over your lunch hour today. We have an action-packed, substance-rich presentation for you today. I'm Kelly Stoner. I work with the Tribal Law and Policy Institute. I'll just say a few things about myself that might be relevant to my expertise in the area. I've worked for TLPI for over 13 years. TLPI is a national technical assistance provider to tribes across the nation on a variety of different topics. My area of specialty is tribal courts, and I have worked since 2013 with the Intertribal Working Group as a part of my TA. The Intertribal Working Group is made up of tribes across the nation that are either implementing special tribal criminal jurisdiction over non-Indians for committing covered crimes in Indian country. I also spent 8 years on the bench with the Seminole Nation of Oklahoma as a district court judge there. I currently sit on the Mandan, Hidatsa, and Arikara Supreme Court as an associate justice there. I've spent 22 years as a law professor, both in North Dakota and Oklahoma law schools, teaching courses on American Indian law, tribal law, domestic violence and the lawyer, and the Indian Child Welfare Act. I'm a former commissioner for the ABA Commission on Domestic and Sexual Violence. Just finished up my last meeting there, maxed out my years on the commission. And let's see, I also spent 8 years as a tribal prosecutor. I mentioned that because I think it helps round out the lens at which I can look at some of these issues. Also, just wanted to shamelessly promote, I also co-author the Indian Child Welfare Handbook. It's in its 4th edition. It's published by the ABA Family Law Section, and that should be coming out, I think, I'm hoping in the next 9 months. And Judge, I'll turn it over to you.
Thank you, Kelly. And as you all heard, we are very lucky to have Kelly as one of our presenters here today. My name is Kendra Bertschy, and I am a Justice of the Peace in Reno Justice Court. So as part of my job, I do see a lot of protective orders. I oversee a docket that includes our protective orders, and as well as a criminal docket that deals with our bail decisions, which have, as you'll hear, a lot to do with our protective orders as well. Previously, I was with the Public Defender's Office, where I was a lobbyist, where I worked on a lot of our Nevada statutes to include some of the issues that we'll be discussing here today. I also teach at the University of Nevada, Reno, where I teach a course on families and public policy. So we, as well with that, have a lot to do with what we are covering here today. Right after law school, I worked for a family court judge in Reno Justice Court, addressing temporary protective order issues for domestic situations. And I was also a victim advocate, assisting victims in their applications for protective orders. I've also served as a CASA, so court-appointed special advocate. And I have also worked as with what was Washoe Legal Services, where I represented victims of crimes of children involved in the foster care cases. So I have a lot of experience on the legal end for these types of cases, and I'm looking forward to our presentation here today. So I'll go ahead and we'll turn to the next slide, please. To discuss our learning outcomes. So our learning objectives today are to understand the importance of enforcement of tribal protection orders, to understand the underpinnings of the federal statute regarding the full faith and credit, and that's 18 USC 2266 for protective orders, and the Nevada full faith and credit statute. To understand the Violence Against Women Act, so VAWA, federal definition of a protective order, a protection order, and the Nevada definition of a protection order. Understand the necessary protection order language to activate the VAWA full faith and credit mandate, and understand whether tribes have criminal jurisdiction to prosecute violations of state-issued protection orders when these violations occur within Indian country. Next slide, please.
Okay, I think this is my slide, right, Judge? All right, just before I start, I just want to give just a little bit of background about working with tribes across the United States. And for those of you who may not be that familiar with it, tribes are all very different with respect to their language, their family structure, their customs, their traditions, and they also are very different with respect to the resources that they may have available to load their protection orders into the federal system, the NCIC. And so I just want everybody to be mindful of that. Some tribes are very progressive, very large with lots of resources, and other tribes are still working on their infrastructure as they move through these particular kinds of issues of issuing and enforcing protection orders. So why is it important that we have cross-jurisdictional enforcement of protection orders? Well, it provides safety to victims and their children as they move across jurisdictional boundaries. I know that just for instance, up in northeastern Oklahoma, that there's a tribe that borders Missouri, Oklahoma, and Kansas. Actually, there are casinos in Oklahoma. If you go outside and turn to the left in the parking lot, you're in Missouri. If you turn to the right, you're in Kansas. Imagine you're a victim with a protection order. You really want it to be enforceable no matter which parking lot you're in, no matter if you jump in your car to go to the grocery store. It's very important to tribal victims, especially. It provides reassurance to the victim that no matter where they go, if they go shopping at Walmart, that if the order is violated, it will be enforced, recognized and enforced as it's written. It also sends a message to perpetrators, abusers, whatever term you want to use, that violation of a protection order, tribal or otherwise, is going to have consequences. And it's also, particularly for tribes, especially for tribes, it's instrumental in recognizing tribal sovereignty when you recognize and enforce a tribal protection order. Next slide. And we'll move right into VAWA, the Violence Against Women Act, as Judge mentioned, VAWA, Full Faith and Credit. And we're doing lots of trainings with tribes on this. I think I'm doing one next Friday even on how to activate the full faith and credit of this federal mandate to recognize and enforce, I want to say qualified protection orders, because it's not every protection order. It's protection orders that have particular language in it. And this is what full faith and credit for protection order means. I think we already said this in the other slide. Sometimes I get ahead of myself. So let's go to the next slide. The victim can move around. They're not concerned that if there's a violation outside of their tribal Indian country, that the order is not going to work. It's not going to be recognized. It's not going to be valid. So the statute is listed there for you, and I'm not going to read it, but basically what it's saying to you is that if a protection order is consistent with subsection B, which I'll go over in just a couple of minutes, that's the activation language, any protection order that's consistent with that shall be accorded full faith and credit by the court of another state, tribe, or territory. And here's the kicker. This is just a key underpinning of what Congress was trying to achieve here. That protection order that meets the requirements of subsection B is to be enforced by the enforcing court and law enforcement personnel of the enforcing state, Indian tribal government, or territory as if it were that state's order. And it doesn't really matter if you can't get whatever's in this protection order, you can't get those type of remedies in your state. If the order triggers or activates the full faith and credit by its language, it needs to be, it must be, it's a mandate, be enforced as it's written. And I give you an example. In Oklahoma, the protection order statute does not allow state judges to address custody issues in a protection order. Oklahoma's home to 36, 37 federally recognized tribes, and most all of those tribes allow the tribal court, the tribal codes, their laws allow the tribes to address custody issues. So when a person who gets a tribal court order in Oklahoma goes outside of their Indian country to visit, that custody order must be enforced as it's written. So that's just an example. Next slide, we're going to take a look at subsection B. Okay, here it is. Here's what it has to have in it. I'm going to start with 1. The order needs to state that the issuing court, we'll talk about tribal courts here, has jurisdiction over the parties and the subject matter under their own laws. And I've been encouraging when I do these trainings to have tribes put their tribal citations in there, because many tribal codes are online now. So if you were curious, you would look and you could see that they would have jurisdiction over the parties or the subject matter. And then reasonable notice and opportunity to be heard has been given to the person against whom the order is sought, the respondent, the defendant, whatever you're going to call them there, that they have been given reasonable notice, an opportunity to be heard. And if it's an ex parte order, that they haven't been given notice yet, but they're going to be given notice, reasonable notice, and opportunity to be heard according to tribal law. So that's the language that we're going to be looking for in the tribal protection orders that are going to activate the federal full faith and credit mandate. Next slide. I want to mention here, we don't have a slide on this, but there is also in 2266 certain rules for counter or cross petitions for a protection order. Those happened so often when I first started practicing, and now they seem to be getting less and less. But basically, the judge there must make specific findings on the record that each party is entitled to a protection order according to the law of that jurisdiction. Okay, this is just a checklist for you if you don't want to go back and read the whole statute. This is what activates whether it's another state issuing a protection order, whether it's a tribe or a territory. It needs to have this language in it. Okay, next slide. Let's take a look at what falls under the federal definition of a protection order. I personally don't like these little bullet points. I'd rather put the statute up, but it is rather convoluted. So let's just go with the bullet points. I will add one thing in here. Any order that's issued by a court, whether it's state or tribal, it can be civil, it can be criminal. If the order fits within the definition of a protection order, it doesn't matter what the order is called. So you have to look a little further. It may not be called a protection order. It may have a variety of different names, but the order in its essence must preclude or prevent or address violent or threatening acts, harassment, sexual violence, or it's addressing contact or communication with another person. Any of those things, it doesn't have to be all of them, will qualify under the federal definition of a protection order. There's one little thing that's left out of this slide, though. I don't want it to escape your attention. If you're trying to decide if you have a protection order in front of you, it also says that the order must be filed or a motion made by or on behalf of the person seeking protection. That's a pretty important piece that you'll want to look at in the orders as well. It includes a whole host of provisions in it: child custody, visitation, any of those remedies that are within that order are within the federal definition of a protection order. Next slide. I'll turn it over to you, Judge.
Thank you. So in Nevada, I just wanted to highlight some of the really common areas that we see for protection orders. I know we have a lot of Nevada judges who are on this webinar, but just to make sure you have that statutes at your fingertips. The most common ones that we do see, or that are the same ones that we just talked about, that Kelly talked about for in the federal statutes, but here's the Nevada statutes related to domestic violence, harassment in the workplace, protection for children, and for orders for protection against high-risk behavior. Each one of these statutes sets forth the requirements for what qualifies under these different types of statutes. I'll also note that these are not the only type of protective orders that we have out there. For example, you can get a protective order in a civil case that's part of a settlement conference. There are protective orders that are set forth in juvenile law, so with juvenile orders. There are also ones in our bail statutes. So for a criminal case, the judge can set forth a protective order pursuant to statute that is its own separate protective or no contact order, as well as a pursuant to a condition of release. So even within our criminal statutes, there's a lot of different types of protective orders. They can be done during the sentencing requirement, so it could be a requirement of probation. So the main reason why I put all that out there is because we have such a very complex system involving protective orders. Just to be mindful of that when you're reviewing orders from other jurisdictions. They may not look the same way that ours do, but they could still be determined to be enforceable. Next slide, please. So with that, we'll turn to the Nevada Full Faith and Credit Statute. And thank you, we'll go back to that one, thank you. So with this, the statute that applies is NRS 33.085. Now, we don't have the statute here. We will go ahead and provide that in the chat. It's Assembly Bill 369, just modified this. So as of October 1st of 2025, there will be some additions to that. Luckily, not much will change for judges. But I did want to provide that to us all so we have the information for what's to come. So currently, the way that our statute reads is that, except as otherwise provided in subsection 2, an order for protection against domestic violence issued by the court of another state, territory, or Indian tribe within the United States, including without limitations any provisions in the order related to custody and support, is valid and must be accorded full faith and credit and enforced by the courts of this state as if it were issued by a court in this state, regardless of whether the order has been registered in this state, if the court in this state determines the following. So I want to pause there and just make sure it's very clear that in order for the courts to find that full faith and credit applies, it does not matter if that order had been registered in the state of Nevada. It's really important because you do not have to register that other protective order. Then the issuing court has jurisdiction over the parties and that the subject matter under the laws of the state, territory, or Indian tribe in which the court was ordered. So that's the first thing that the state has to determine. Then the adverse party was given reasonable notice of an opportunity to be heard before the order was issued, or in the case of an ex parte order, the adverse party was given reasonable notice and an opportunity to be heard within the time required by the laws of the issuing state, territory, or tribe, and in any event within a reasonable time after the order was issued. Now, reasonable time is very important because that is obviously something that is up to some judicial discretion. I'll note that in the testimony from Shea Backus regarding this bill, there was some discussion about reasonable notice. So if that comes to be an issue, there is some legislative intent regarding this specific language for reasonable time. Additionally, you probably have heard and may recall that Kelly just talked about a lot of the same information. So our statute is really derived from the federal full faith and credit. And our statute came forward in the 71st legislative session, so in 2001. Now, subsection 2 discusses for domestic violence. So if the order for protection against domestic violence issued by the court or of another state, territory, or Indian tribe is a mutual order for protection against domestic violence, and no counter or cross petition or other pleadings was filed by the adverse party, or a counter or cross petition or other pleading was filed, and the court did not make specific findings of domestic violence by both parties, the court shall refuse to enforce the order against the applicant and may determine whether to issue its own temporary or extended protective order. So I think that's very important because it explains the next process for what to do when the court finds that it is permissible to refuse to enforce the order, but if circumstances warrant it, the court can then issue its own temporary or extended order. Now, subsection 3 discusses the way that a law enforcement officer shall enforce the order. So I'm not going to go into all of those details, but just know that it has specific requirements for law enforcement officers for the enforcement of those protective orders. In subsection 4, this is where the law changes as of October 1st. Again, it's mostly for the enforcing officers, but the court does have some provisions that it can look at as well. So it states, in enforcing an order for protection against domestic violence issued by the court of another state, territory, or Indian tribe, or arresting a person for a violation of such an order, the law enforcement officer may rely upon a hard copy or digital image of an order for protection against domestic violence that has been provided to the officer, an order for protection against domestic violence that is included in the repository for information concerning orders for protection pursuant to NRS 33.095, or in any national crime information database, oral or written confirmation from a law enforcement agency or court in the jurisdiction in which the order for protection against domestic violence was issued, that the order is valid and effective, or an examination of the totality of the circumstances concerning the existence of a valid and effective order for protection against domestic violence, including without limitation the statement of a person protected by the order against that order remains in effect, and any statement by the person against whom the order is being enforced. So what's changed in this statute is that in order for law enforcement to find that there's been a violation, the court can use a hard copy, or the law enforcement officer can use the hard copy or digital image of the order for protection when it previously had to be just a copy. And so it clarifies that it could be on somebody's phone, just a screenshot of that order, and that's enough. Additionally, the law has changed where now the law enforcement officer can rely on a statement made by the adverse party. That's important when we're looking in criminal proceedings for whether or not somebody's violated that protective order. Then subsection 5 is completely new, where it changes the service of process. I'm not going to read it all to you, so just make sure to review that. But it provides much more lax standards and different ways for a police officer to be able to serve those restraining orders. And they can even verbally provide it to them as well, and then make the documentation. So it increases the ability to have the adverse party served. Subsection 7 is the subsection that indicates that the order does not have to be registered or included in the repository for it to be determined to be a valid order. And it is not, and just because it's not in the central repository is not ground for law enforcement to refuse to enforce the order. Subsection 8 is very important for the courts to know as well, is because that's the subsection that indicates that law enforcement officers and the courts are immune from civil and criminal liability for any action regarding if a court or law enforcement officer enforces an order for protection against domestic violence issued by the court of another state, territory, or Indian tribe based upon reasonable belief that the order is valid, or who refuses to order such an order based upon reasonable belief that the order is not valid. Next slide, please. So some tips for improving enforcement outcomes. What I will just note before we get to that of just why this is important. I appreciate that everyone's here. So obviously you all have some basis to think that this course was important. But what we've noticed is that one of the barriers for survivors of domestic violence is the enforcement of tribal court protective orders. And that's not something that is just Nevada specific, but just in general across the nation. And so I do really appreciate everyone taking the time to be here to learn more about this really important issue.
May I say one thing, Judge? Sorry to interrupt.
Please
I forgot
do.
to say this earlier, but this may be an issue that comes before the judges. The federal definition of protection order is so broad, it will include no contact orders that your prosecutors might be requesting. Remember, the prosecutor has to request that by or on behalf of the victim. Some jurisdictions require prosecutors in domestic violence cases to request a no contact order. But if the no contact order has the activation language in it, it can be treated as a protection order and enforced through VAWA and perhaps be the basis for another criminal action. So I think that's important, and I forgot to say that. Apologies.
No apologies needed. Thank you, Kelly. Yes, that is really important for us to all be aware of. So thank you. So just some statistics that I think are really important for us to all keep in mind. According to the American Constitution and Society for Law and Policy from 2009, from an article of addressing the epidemic of domestic violence in Indian country by restoring tribal sovereignty, Mr. Fletcher writes that every hour of every day, an American Indian woman within the authority of a tribal court is the victim of sexual and physical abuse. American Indian women residing on Indian reservations suffer domestic violence and physical assault at rates far exceeding women of other ethnicities and locations. American Indian women experience physical assaults at a rate of 50% higher than the next most victimized demographic, African American males. About 1/4 of all cases of family violence, so violence involving spouses against American Indians, involve a non-Indian perpetrator, a rate of interracial violence 5 times the rate of interracial violence among other racial groups. In all, 39% of American Indian women report being victims of domestic violence. In Nevada, the U.S. Attorney General's office has noted that Nevada is home to 28 federally recognized tribes, bands, and communities located on 31 Indian reservation and colonies. Why this is really important for especially some of the rural jurisdictions to learn more about. I know that we have a judge who's here from Elko, and in Elko, Nevada, the Bureau of Indian Affairs, the BIA, has their office is slated to close on August 31st of this year. So we'll hear more from Kelly as to why that's important, but I just want to highlight that for our Nevada judges. And then with some Nevada specific statistics from the Nevada Coalition to End Domestic Violence, Nevada currently ranks 5th in the country for most rape per capita cases of 67 rapes per 100,000 residents. Nevada ranks 2nd in the country for rates of domestic violence with 44% of women and 33% of men experience intimate partner violence. And the Violence Policy Center has reported that Nevada has ranked in the top 10 states with the highest rates of women killed by men in 23 years out of the past 25 years. So now it tips to improve these enforcement outcomes to hopefully reduce some of those really horrible statistics. If we look at our own orders, there are things that our courts can do. And so just for the facilitating protection in our orders when we're issuing of them, you can provide parties with certified copies of the order. We can suggest that when we're issuing the rulings from the bench, you can suggest that parties keep copies of them at all time, or to talk to the advocates about whether or not they wish to have them on them. The courts can include in the required judicial notification regarding federal firearm laws. The court can inform parties orally or in writing that the order is enforceable in all 50 states, U.S. tribal, territorial lands, the District of Columbia, and military installations. The court can state that violations of the order, in addition to any state or tribal sanctions, may be subject the respondent to prosecution for such federal crimes as firearms or ammunition protections, interstate travel to commit domestic violence, interstate stalking, interstate policy violations, protective orders, as well as provide information regarding hotlines for domestic violence. And when we're looking at what procedures the court can use to apply as the enforcing jurisdiction, it's really important to be mindful of, even if the order that you're looking at has protections that are not permissible in your protective orders, they are still applicable because you're applying their law. So for example, if the other jurisdiction has a law where they include in their order that a part of that protective order is for pets, even if our state, which our state does, but if our state didn't have that as part of our protective orders, that's permissible, it is still required as part of the enforcement. So you still have to, that is part of what the court can be considering. For example, if what we see a lot of that for other jurisdictions don't include firearm protections, or they do include firearm protections. So there's some of those states that have those issues that luckily our state does include that requirement. So if we see it from another jurisdiction, that wouldn't be an issue, but that's just to be mindful of. If you see something, for example, like that, it may include that the petitioner has to pay cell phone service or maintain payment of the cell phone service. Even though that's not something we typically would issue, we still have to do it. I'll just say that I've seen that from California, where they have protective orders that say like no harmful contact. So we don't have any protective order that is just prohibiting no harmful contact, but that is still enforceable. So if we see a violation of that come through, that is still, it's a violation of a protective order. So even though that's not something that we have in statute, we still have to find that it is enforceable because it did qualify for the full faith and credit.
May I follow up on that?
Absolutely,
Jesse, sorry, I can't tell I have a delayed video going on here. I just wanted to stress how important, and you're hitting on it, how important the remedies are when you're drafting your own protection orders as judges from the bench, with an eye towards, can a prosecutor prosecute this as a violation? I think the harmful behavior, that's going to be tough as a prosecutor. I might try, but it's difficult. So the remedies also need to be drafted concretely enough so that they can be enforceable. And just a reminder for any of us who work in the domestic violence field, every single order that comes from the bench with respect to the case, the advocates need to be safety planning, because what's happening in essence is the behavior's gotten so out of control that the court is having to take control away from that defendant, that respondent, and literally tell that respondent what they can and cannot do. And that's one of the most dangerous times for the victim.
Thank you, Kelly. I think that's really important for us to all be mindful of. Another tip that I think is important for our judges to know is you can include in your order that it satisfies the requirements of full faith and credit. So that's something as well that we can include and make part of our orders, and to ensure that the parties know that this is an order that is valid everywhere. Next slide, please. So now we want to turn to get more information about what you all have in mind. And so we'll go ahead and turn it to a polling question. So if you have not used Slido before, welcome, this is a wonderful tool. But you'll see a QR code that you can scan with your phone or a website. So if you could please scan that QR code or type in that website, because we want to hear your answers to this question of, do tribes have civil authority to issue and enforce protection orders involving any person on matters arising in Indian country? So I'll give you guys a few minutes to please input your answer. So rating, I'll just read it one more time. Of, do tribes have civil authority to issue and enforce protection orders involving any person on matters arising in Indian country? Yes, no, or unsure. And we'll give you guys about 30 more seconds to input that. All right, and Ms. Bowman, do we have the results? Yes, all right, Ms. Stoner, I'll turn it to you.
Okay, great. I like that answer. All right, well, here's the statute. Most of you got that correct. You get an A. This is what this particular statute says. I'm wondering if that's an error. I think no, it isn't. It's correct. For purposes of this section, a court of an Indian tribe shall have full civil jurisdiction to issue and enforce protection orders involving any person. That's a big deal, because before this, we had a case out of Washington make its way through the federal court system there. We had a non-member Indian wanting to get a divorce from a non-Indian. They both resided in Indian country. They'd used the tribal court over and over. The non-Indian defendant decided he wasn't getting what he wanted out of all this, and he went over to seek a federal writ of habeas corpus because he said the tribe didn't have civil jurisdiction over a non-member and a non-Indian. And so there's a case, Montana versus United States, and it's a case that I'll give you the site to it, 450 US 554, 1981. That's the go-to Supreme Court case for tribal civil jurisdiction over any matters that involve non-member Indians and non-Indians. I know that sounds really strange, but in American Indian law, we have to know the race or a political affiliation, whether a person's enrolled, not enrolled. And for the civil realm, that Montana case lumped non-member Indians in with non-Indians. And this cleans that up. It partially overrules that Supreme Court case and makes it clear tribes have full civil authority to issue and enforce protection orders involving any person. And I italicize the other, it says you can do it in orders of contempt, you can exclude violators from Indian lands. But the matter has to arise in Indian country for the tribal court to have this authority, or otherwise within the authority of the tribe. So this is the jurisdictional basis that changed everything for tribal civil jurisdiction to issue protection orders over any person. So good, you got that right. Next slide. Yeah, there we go. There we go. And this is just a checklist for you all to pull out if you don't want to have to look at the whole deck again, to activate the federal full faith and credit enforcement of protection orders. Again, it's having to do with jurisdiction over the matter, the parties, reasonable notice and opportunity to be heard. It has rules about ex parte orders, and it also has specific rules about counter petitions. Next slide. Do we have any questions out there? If you do, just put them in the chat. Okay, we have another Slido question. Here's the question. Do tribes have the criminal authority to prosecute violations of state court protection orders where that violation occurs in their Indian country? Here we go. Same rules. Use your phone. This one might be a little trickier.
So I know we have a question about, if you could please repeat the question, Ms. Stoner.
Oh, okay. Do tribes have the criminal authority to prosecute violations of state court protection orders where that violation occurs in their Indian country?
And while people are answering that, Kelly, I think we also had a question if we could get that citation for that case again.
Sure. It's Montana versus United States, 450 US 544. It's a 1981 case. There are other Supreme Court cases that came after, but that was the beginning of this Montana test that tribes have to meet if they're going to have exercise civil jurisdiction over non-members on fee land in Indian country. Nothing is simple when we're talking about jurisdiction in tribal courts. How are we doing on the answer?
We've got 8 answers now. We can go ahead and go to
Let's
the
see what
results.
folks are saying.
Perfect.
Oh, good. 75% say yes, 13% no, 13% unsure. I think you might need a few more facts, but the answer is going to be maybe. So let's go. It's going to depend on the race of the perpetrator, the race of the victim. We're going to have to go through all of that. There is a Supreme Court case, though, where this answer would have been no up until 2013 if the offender was non-Indian. We didn't give you that little fact there, but you have to know the race of all the parties or political affiliation of all the parties in Indian country in most instances to tease out whether there's jurisdiction or not. So there was a case from 1978 called Oliphant versus Suquamish. And basically the United States Supreme Court in that case said, tribes have no criminal authority over non-Indians committing crimes in Indian country. Tribes just can't prosecute those people. It would either have to go federal, or if it was a public law 280 state, they might come in and take it. And this was before Castro Huerta and all the other cases. So once we got VAWA 2013, this partially overruled the Oliphant case to say that tribes that can meet the mandates of the federal law that want to start exercising criminal jurisdiction over non-Indians who commit crimes against Indians, they could do that then. That was a big ordeal. It wasn't that easy. But then we fast forward up into VAWA 2022. Let me tell you first, though, 2013 only had 3 crimes in it. Can you imagine? The tribal judge only has authority if they can meet the due process mandates of the statute, the VAWA 2013 statute. The prosecutors could only prosecute the non-Indians for committing domestic violence or dating violence or violation of a protection order with an Indian victim. Does that make sense? So that's where we were in 2013. the tribes that began to implement, it was such a big ordeal. The tribes had to get their codes approved by the Department of Justice, that they met the due process mandates. There was a requirement, it still is, that their jury pools could not discriminate against any race, including non-Indians. So some tribes were already having non-Indians on their criminal juries, others were not. So the tribes that were implementing 2013 went to Congress and they began to lobby and say, here's where it's going great. Thank you. We're exercising our inherent sovereignty once again. But what about the children? When we arrive at the scene and the children are physically abused, we can't prosecute that, the non-Indian, for abusing the Indian children. That's not included as a crime in VAWA 2013. What happens if an elder gets in between and gets injured? We can't handle that. Our law enforcement are being assaulted when they arrive at the scene of a domestic in Indian country. We can't prosecute the non-Indian for doing that either. So fast forward to 2022, and we get Congress actually listening and actually coming out with 9 covered crimes now that can be prosecuted. Non-Indians can be prosecuted for committing in Indian country. Let's go to the next slide. Oh, that's it. Okay. Well, let me tell you what one of those covered crimes is. We still have dating violence. We still have domestic violence. We still have violation of a protection order, but it's only certain provisions of the protection order that can be, the non-Indian can be prosecuted for violating an Indian country. And it's those provisions that deal with no harassment, no abuse, no contact or communication with. It's not child support. It's not any of those things. So it's a narrow alley there. We also have the covered crimes of sexual violence. We did not have that before. We have the covered crime of assault of tribal justice personnel, because Congress was listening. We have child violence. Again, this is the fact pattern. Non-Indian with an Indian victim. We have sex trafficking. We have obstruction of justice, which I, as a former prosecutor, just love. And so what you need to know about that is all of those crimes have to have this particular fact pattern. They have to have a non-Indian violating one of these 9 covered crimes if the tribe is implementing STCJ, Special Tribal Criminal Jurisdiction. And in all but 2 of those 9 covered crimes, we have to have an Indian victim. But in 2 of the covered crimes, obstruction of justice, which I can envision happening in a lot of domestic violence cases, and assault of tribal justice personnel, it doesn't require an Indian victim. And so that sort of overrules another Supreme Court case, partially, McBratney and Draper, which said if it's non-Indian versus non-Indian in Indian country, it comes to the state court. Now the tribes can address it and the state court can still address those violations. So protection orders become extremely important. The way they're written becomes extremely important. We want to be sure that we're given all the information to tribes about how to activate the full faith and credit mandate. And I did ask one of my colleagues, are there any tribes in Nevada that are exercising special tribal criminal jurisdiction? And I was told that, I believe it was Las Vegas Paiute, comes to the ITWIG meetings and is considering or working towards implementation of this special tribal criminal jurisdiction. So with that, I think we would move on to our resources here. Can we go over the resources really quickly? Tribalprotectionorder.org is one of TLPI's protection orders. It's designed for tribes. You can take a look at it. It's designed to help tribal judges, tribal advocates, tribal lay legal advocates who are working on protection orders. It talks about the things we've talked about here today. It talks about full faith and credit. It talks about special tribal criminal jurisdiction. It talks about how important it is to draft enforceable remedies. So take a look at that. It's all been updated, and I'm hoping a lot of tribal judges are looking at that to get some of their drafting questions answered. And then, Sarah, we have yours next.
Yes, thank you, Kelly. So our website is thefullfaithandcredit.org. That will bring you all to our BWJP, National Center on Protection Orders and Full Faith and Credit website, where you can find more resources on full faith and credit and protection orders and anything. We have numerous other resources on protection orders on that website as well. So feel free to check it out.
And then we also have protection order checklists that I've worked with Sarah's organization to develop. And we're hoping tribal judges will use those to tailor those jurisdictional statements in their protection orders. And then I think we have one of Stephanie's here, the Civil Protection Order Guide Project. We had a little bit of everybody working here with these resources. Do you want to say a word about that resource?
Yeah, sure. This takes us to the project page on the NCJFCJ's website. So it's the page dedicated to all resources around the Civil Protection Order Guide, which is a pretty extensive guide issued by with in combination with OVW. And so there's a lot of different resources there on just different issues that intersect with civil protection orders. Some for court audiences. We have a new bench card on full faith and credit there that you can access, and then others for more collaboration around these issues as well.
And I just want to remind everybody out there, I don't know your experience working with tribes in Indian country, but remember there are vast variances in their available resources. And remember, tribes may not be able to load their protection orders into the database. More and more tribes are getting the Tribal Access Program from the Department of Justice, where the Department of Justice comes in, sets up the kiosk, trains everyone, and then they can enter their protection orders in NCIC. But some tribes, those kiosks have to be manned 24/7. Some tribes just don't have the resources monetarily and even personnel wise to man those. So tribes are working hard to do workarounds, especially the smaller tribes, maybe partnering with a tribe that does have a TAP program, maybe working with a state that's willing to load their protection orders into the database. But that is such an important piece, and it puts victims in such harm's way when law enforcement outside of Indian country, if it's a tribal protection order, can't find it on a database. And we are strongly encouraging victims to have certified copies, but things happen and they may or may not have a copy. And law enforcement has to make some really difficult decisions in the field with respect to some of this.
Kelly, we also had somebody mention MOUs between different agencies and how that can be helpful. So I just wanted to highlight that from the chat as
Yes.
well.
Oh, I'm so grateful because we just put out a new publication with the University of Montana. I don't know if I have it handy here, but if you can get their email address, I can send it to them. It's really created for MOUs from a tribal perspective, where a state might want to partner with a tribe, but it also could work the reverse way as well. It goes through tribal sovereignty clauses. It goes through just a variety of different topics. It was created for MOUs in the Child Welfare Department, CPTs, those sorts of coordinated community responses, but we wrote it generally enough. I think you could use it for almost anything. So if you can get their email address, I'll be happy to send the link to that MOU.
And I just want to highlight then some of the resources again. I know that Ms. Bowman just talked about it from the NCJ, FCJ, the Civil Protective Order Full Faith and Credit Bench Card Series. I highly recommend all the judges to review that. It is a very lengthy document, but it really breaks down for bench card purposes for all the different types and checklists that you can use on the bench. So if you don't already have that printed out and on your bench, we don't see these orders all the time. And so just to make sure that you have all the information at your fingertips when you least expect it, that's a really great resource to have. Additionally, from the Full Faith and Credit website, they have an excellent common questions on protection orders and full faith and credit answered. That really is I think it's a 3-page document that breaks down just with the different questions of when is a protective order entitled to enforcement under full faith and credit, with very clear explanations for what's needed in order to enforce that protective order, which laws applies, that clarifies the jurisdiction that orders the restraining order, what laws apply when you follow those, and then the jurisdiction that enforces the order, what laws apply for that, as well as how orders are enforced by courts and law enforcement. So that's a really great resource. If you only have 2 to look at out of all of the resources that we're providing with you, those are the ones that I highly recommend.
Do we have any more questions? Anything at all about Indian country or working with tribes? Or I would wonder if you have a tribal state forum that meets so tribal judges and state judges can discuss topics. Maybe not every jurisdiction has one, but.
So I was going to say, if Nevada doesn't, it's always a great idea. I think both Sarah and Sarah's organization, our organization always really push for community coordinated efforts. And that is one of those types of avenues to really make sure that communities are on the same page and that everybody understands roles and helps to initiate those kinds of MOU conversations and other types of things as well. So if not, it's definitely something to consider. So thank you for bringing that up. Oh, and we do have a question regarding if there's any information on why the Elko office is closing.
May I guess? I don't know. I would say drawdown of federal personnel and the impact I think that would have on the tribe. I don't know. I've never visited that particular location, but usually they provide a lot of different services for tribes, lots of services. That's where the tribes would go. And they perform important governmental functions like approving, in some instances, tribal codes if that's necessary. And sometimes there are Indian Health Services facilities located there, and that's where Indian people would be going for their health care, their dental, all of those kinds of things. I would think that would be a very big deal to them.
And I think that was the last question that was in the chat. Thank you so much, Judge Bertschy and Kelly, for this wonderful webinar. What great information, especially for the people that are signed on, but we're really glad that this will be recorded as well. So thank you all for joining us. And again, thank you to our faculty today.
Thank you
Thanks
again
for
for having
joining
us.
us.